So I don't know how many so I am on the board of the San Diego League. Stephanie Sontag, who should be right up at the top there, is a league member and a retired judge. So we're really excited to have her experience with this complicated subject. So let me just tell you a little bit about how we're going to structure this. So I'm going to give a little bit of an introduction. We do have a PowerPoint deck because we think people are kind of used to organizing in that way. There are, as I think most of you know, 12 questions. And we're going to kind of go through the 12 questions in order. Some can be lumped together. And I will give a little bit of background in the beginning and then turn it over to Stephanie. We will try to have questions, if not after every topic, at certain points. So let me just say a little bit more about this process for the league. I know a lot of you are very familiar with this, but this study was initiated by the National League, and it was voted at the convention in Washington last summer. And it was interesting at the convention because it was originally only the federal judiciary, but the convention asked to have it include also the Supreme Court because there was a lot of feeling about the Supreme Court. So what's going to happen next week is the league consensus meeting, which has, a very set structure. And what we want to come away with, which will go to the National League in order to put together a new position, is that we will, for each of the questions, have a chance to check off whether there's strong consensus for, moderate consensus for, strong consensus against, moderate consensus against, or no consensus. And then with each of the questions, we have room for each league. So, North County will do its own. There's room for a 100-word comment. And then at the very end, there's room for a 400-word comment. And I think that's kind of where some of the personality and, themes of each discussion will.
Do you want me to go upstairs?
No. I'm going to be in the kitchen. I got to get something to eat.
Yeah, Vicky, I think you need to mute yourself because.
Mark, how do I do that?
If you go to the upper right, well, maybe he can help you with it. Maybe I
can mute.
Any rate, so there's room for, some color. And okay, so those are the basic overview. Does anybody have any particular questions about the process? Okay. Oh, good. Kim Knox is now the host, so she can help. All right. I am going to share our screen, which has our PowerPoint. And so one of the things I would like to mention is that in terms of questions, we're not going to use the chat particularly. I will keep an eye on the chat, but we're mostly going to have people raise their hands using the raise hand function, which is at the bottom of your screen. It should be, at least. So if you hit that button. Is there anybody who has questions about the raise hand function? Okay. All right. So let us get started. Okay. I think I've already said quite a bit about the consensus process. Somebody is trying to reach me. Okay. So the first 4 questions are very general. And then we get into some more detailed ones. You don't have to be a lawyer to respond to all these questions. But I think one of the particulars is that the questions are written to be principles. They are not specific changes to the judiciary. It's not going to be, we should expand, we shouldn't expand. We can comment on that in the comments, but Generally, as most of you know, league positions really are about something quite general, so it'll be applicable for many years. Okay, so now. So this is, I found, it was in the materials that the National League put together, but I found it very helpful for somebody who isn't a lawyer to understand in particular these three layers. And starting, we're not involved in this study with the military courts and the veterans claims, but we do talk about the US district courts, which are 94 judicial districts, and there's the Court of International Trade. There are, I think this is interesting, there are actually 680 judges in the district courts, and they're pretty closely divided by Democratic appointed and Republican appointed, 370 to 267. Oops, hold on a minute. The appeals courts are divided into 12 regional circuits. You know, they talk about the Circuit Court of Appeals and the appellate courts. That's what this level is. And there are 179 appellate judges, also evenly distributed between Democratic and Republican appointed. And then there is, of course, the Supreme Court, which I think most of you know pretty well. I thought this map really shows the different districts. There's somebody who isn't muted, and I think if most people will mute as a general rule, unless you're asking a question, that will be helpful so the rest of us can hear. Now, the whole West is in the Ninth Circuit. The Fifth has been in the news a lot, and we will be talking a little bit about judge shopping and district shopping, but there are 12 districts, I believe. So the next one is, before engaging in this study, I really didn't know about or much about the Judicial Conference, which is a very important kind of governing body for the federal courts. And it's very involved in enforcement and codes of ethics and ground rules. So it consists of the Chief Justice of the Supreme Court and 26 members. So there's 12 from each of the appellate court districts, and then the chief judge from each of the regional district court circuits. Oh, sorry, once again, I'm jumping ahead. And the budget is approved by Congress. But I think the role of the chief judges, you know, in terms of enforcement is very important. Okay, so I'm going to move it along to Stephanie.
All right. Well, thanks, Jane, and thanks everybody for coming. And I was not a federal judge. I was a state superior court judge. So I just wanted to give that disclaimer, although I think I know a lot about the federal judiciary, especially after looking into everything here. So what I'm going to do is just go through the 12 consensus areas. They're stated as statements, and then in our consensus meeting, of course, we'll be discussing them and deciding what the consensus is in response. The first general statement is transparency is essential to an effective federal judiciary. And typically, as I'll explain a little later, things are pretty open in the judiciary about what the public can see and do, and the material they have access to. But transparency has a little bit of a problem in what is called now the shadow docket of the Supreme Court. And that has always been the Supreme Court is available for emergency applications. And they used to be really restricted, but it's being used a lot now. And what happens is a trial court, the very first court is the trial court. It's typically merits-based rulings by the Supreme Court. They get the case after the district court has had the trial or a resolution and a decision is made. It's gone to the appellate court for review, and there's typically although there's no more evidence presented, there is an opinion by the appellate court. And then it gets to the Supreme Court. The Supreme Court has all the briefing, it has the transcripts from the trial, and it has oral argument before it issues a written ruling. And the shadow docket, it's an emergency application for an order that the trial court has made in the initial stages of the proceedings. So that's before any evidence is presented, before the trial proceeds. And it's usually something like seeking to bar enforcement of a challenged statute or restrain enforcement of a court order granting or denying emergency relief during the litigation. You've all heard about restraining orders that judges have issued that are nationwide, and it goes up for an emergency order to the Supreme Court saying, take away that restraining order. So the court gets the application, very limited briefing. There's no evidence yet because there hasn't been a trial. And all cases by the Supreme Court are received by the Supreme Court because they want to hear them. They vote to take cases both in the normal course and in emergency orders. So if they vote to get this case, they decide among themselves, and then they typically issue a brief order such as relief is granted, signed the court. And so there's no reasoning provided, and it's a little bit of a mystery about why the court is ruling the way it is. So going to the next slide, the emergency relief is sought and provided on very consequential issues such as voting rights, gerrymandering, reproductive rights, environmental regulations, capital punishment, and more. So there's this whole body of decisions, but not really law. And so although this will come up a little later, I thought it was pertinent to the transparency argument because this is a part of the judiciary and its rulings that is not transparent. So at any time, if anybody has a question, please let me know.
I'd pause. It looks like Kathy Green has one.
You're muted.
Kathy, can you unmute yourself? You are muted. Kathy, I wonder if she can. We can't hear you. You've got to unmute yourself. If you go down to the lower left, it should say audio.
There we go. There we go.
Yay.
I couldn't get the button to work. When the Supreme Court decides to take something that has not been, completely gone through lower courts, does it have to be unanimous that everybody on the court wants to take it? And how do they decide that? And what if some of them really object to this?
Well, then they can say we dissent.
That's it.
But it's a majority vote.
But and then any decision would have to be a majority decision, any decision they make on the case.
That if the order, yes, would have to be a majority order. Otherwise, they would just let it stand.
Okay. And I have to take the hand off.
Okay.
Any other questions on this segment? down at the bottom where it says react, if you click react, then you'll see the raise hand button. I don't think I was clear about that at the beginning. Hold on a sec. Sorry. Okay, shall we carry on?
Let's carry on.
Okay.
And while Jane's pulling up the slides.
Oh, you know what? Sorry, I've got I'm having a little trouble here. Okay. Sorry, it's there we go. Okay.
And just while you're pulling it up, the
Yeah.
shadow docket is kind of a derogatory term because people don't like the fact that these decisions are made in the shadows rather than out in the open. All right, the next three topics are the three other general topics before we get to just more specific areas. And they'll be discussed in more detail below, starting with accountability. Should each individual judge or justice be held to uphold the law neutrally with consequences if they fail to do that? Are there systems in place that would assure they are held accountable if you believe accountability is a good goal? If there's a consensus for this. Independence, I'm going to give a plug for independence, although I'm trying to stay neutral. But the judiciary is a co-equal branch of government, but its independence is assured so long as the judges and justices do not forfeit their power and independently decide cases according to the facts and law, and the other branches of government respect their rulings. The courts do not have any kind of enforcement mechanism other than the Constitution piece of paper and the willingness of everybody to uphold the law. And as far as ethics, I think that again is probably something that's obvious that judges and justices should have ethics. And that's going to be discussed in a lot of detail as we continue here. I do want to say, I keep on saying judges and justices. All of the bench officers in trial courts and appellate courts are just judges. Justices are only in the Supreme Court. And the lawyer joke is that in the federal system, you don't get any justice until you get to the Supreme Court. So we just think that's hilarious. All right. So going on to the next one, the next statement is there should be binding universal standards. Next
Sure.
one. That's okay. There should be binding universal standards of conduct for judges and justices at all levels of the federal court. So this is a little tricky because right now there are two standards of conduct and ethics. The lower courts have a binding standard of conduct that is codified and which comes with enforcement mechanisms that I'll talk about in a minute. The Supreme Court does not have the same kind of enforceable standards of conduct and ethics, although in November 2023, they agreed to a voluntary standard of conduct, but it does not have any kind of enforcement mechanism except, and I'll probably mention this again, the ultimate enforcement mechanism for all federal judges is impeachment. So that is always an option. But all the judges we're talking about, judges and justices, are what we call Article 3 judges, which means they have life terms and they're all confirmed by the Senate. So there is, at this point, they're there and the Supreme Court again, they're there unless they're impeached. The interestingly, the code of conduct that the Supreme Court voluntarily agreed to is very similar to the lower court standard, except the lower court standard says that a judge shall do certain things, and the Supreme Court says they should do certain things. And in the law, these are very deliberate choices, whether something is shall, meaning mandatory, or should, meaning it's a good thing to do, but it's not a shall. So the Chief Justice and the Judicial Conference ultimately are the only people that can refer to Congress for impeachment for any judge or justice. Going to the next slide.
Stephanie, I just want to jump in a moment here
Sure.
because I think one of the things I looked at in this process was a list of all the complaints. I mean, there are many, many complaints for the lower courts, and that it is the Chief Justice's role to review all those, and many are, not worthy of any action. But then, can you just say a word or two about what the options for the Chief Justice are if he or she chief? I guess it's the Chief Judge.
Of the circuit. It's not the Chief Justice.
Yeah, I'm thinking of, that's
Yeah.
misnomer. But what are his options for enforcement and punishment,
Okay.
if you will?
No, this is fine. I was going to get to that in a minute, but let me discuss it now. It's fine. The every court website except the Supreme Court has a place and a form for a complaint against a judge for judicial conduct or inability to sit any longer on the bench. Those complaints go to the chief judge of the circuit in which that court sits in. Now, the chief judge can look at it and go, "Oh, that's bogus," and just dismiss it right there. If the chief judge thinks that there's further review that's necessary, they will refer it to a committee of their circuit judges, and they will review it. Now, the discipline can be a public reprimand, a private reprimand, taking cases away from the judge for a specific period of time, or in serious cases, they report to the Judicial Conference, which is the one that Jane talked about, that Chief Justice Roberts heads, and they take it up and decide whether there should be a referral to Congress. They are the only ones that can refer it to Congress. And let me just say, with the complaints, that's not a complaint about a decision. That cannot be made that way. A complaint about a decision goes up the appellate process. But this is the conduct of the judge or the ability to continue in their role. Is that what you're asking about, Jean?
Yeah, that's perfect. Thank you. Any questions at this juncture? I don't see any. Wait a sec, let me go up in my,
Oh, I see one.
okay, go for it.
Hi, Jean.
Yeah, could you give some examples of conduct that would be so you say that they wouldn't hold them because of a decision, but because is it personal conduct?
Yes.
That
It would
an
be
alcoholic
conduct
or something like that, or
Yeah, personal conduct in the courtroom. Yeah, demeaning conduct to parties, to defendants, yelling, screaming, not paying attention. It would be all that kind of personal conduct that would be subject to a complaint.
Okay. Both in the courtroom or out of the courtroom.
Well, I have to say, I don't know. I would think so. I know in the state court system, if a judge is out in public doing terrible things, that can affect their job. I would assume federal court is the same, but I'm not 100% sure.
Okay, thank you.
You're welcome.
See,
And
Beryl, yeah.
Do judges have terms? I mean, I know the state ones do, but to the federal judges, if not, maybe part of the issue is watching for Alzheimer's and mental problems.
Mm.
right. I mean, that's a real problem, and they don't have terms. Again, they're Article 3 judges, which means they stay they hold their office during good behavior, unless they're impeached. So they can be disciplined, but really a removal from office is only done by impeachment. But lifetime appointment, that's why you see some more blatant behavior, let us say, from federal courts, federal judges than you do from state judges. Right. Anything else? I see no hands.
Shall we go on? Oh, I do see Kathy Green has one. But Kathy, you have to unmute.
Yep, unmute.
Yay. Okay.
So this would also be this code of conduct that they adopted, which could be anything like having had an interest in a similar, in this case earlier, or any kind of financial interest in a case, things like that.
That would be an ethics violation, and that would be a code of conduct. The failure to recuse yourself, or
Right.
take yourself off the case. Yes. And it would have the same discipline that I just described. And for the Supreme Court, again, there's no enforcement mechanism, so it would only be impeachment.
Thank you.
I think S.A. Peterson, do you still have a question?
Yes, I'm Susan Peterson. Somehow my name never got in, but I have for years been really concerned about whether judges can recuse themselves, and so many times they do not. Is there any appeal process to be initiated by whoever to say, excuse me, you can't make this one-sided decision?
Mm.
That would again go to a complaint that the judge, and we're talking about the lower courts, a complaint that the judge is improperly sitting on the case, that was biased. That would also be mentioned, I'm sure, in an appellate brief, saying that the judge, attacking the decision, saying the judge should not be sitting on the case because of certain reasons. But yeah, I mean, but that again doesn't apply to the Supreme Court.
But
Thank you.
yeah, can I follow up on that? Because so is it possible to complain to the Chief Justice and then he or she consider action?
There's no action to consider. I mean,
Yeah,
there
okay.
has been, there's been the controversy about Justice Thomas, that's all over the news, and everybody says, John Roberts, you should go talk to him, but the Chief Justice has no authority over the other justices, despite his title. That's an administrative title. And so, anyway, that's.
And when they talk about sort of self-policing, which I think is the term that's thrown around, it's really the group of 9 talking with each other, but nothing definite to do.
Well, Yeah, and I would question whether any of the justices, unless they're very, very close personal friends to another one, would go to them and say, you recuse yourself. They have no authority either. And the judge that's refusing to recuse themselves knows very well what their bias is and has decided that nonetheless they should be sitting on the case. So it's not like it's anything new.
Yeah. Thanks.
Hubris.
All
Okay.
right. Should we carry on?
Sure, we're covering a lot of stuff that's coming up, so that's fine. We're making progress. All right, we are at the court rulings, documents filed in the court, and rulings for all federal cases should be open and available to the public. And generally, this is true. It's amazing the public information you can find if you're so inclined. There are, however, some exceptions. There's some things in which the public is not invited and cannot read records, but that has to be approved by the judge. Such as national secrets. When you have a trial involving national secrets, you're not going to be publishing that for everybody to download. Grand jury proceedings are not available, the transcript, unless it's made public as for evidence. And that's because it's one-sided, that only the prosecution presents evidence in a grand jury. And so if you got the transcript, you wouldn't be able to see anybody cross-examine or the evidence tested in any way. Trade secrets are another matter that's sealed with the approval of the court. But what I used to always tell juries is that they are the ones that make sure our trials, and this would be in federal court too, are open to the public with their decisions, because everybody's read about other countries, autocratic countries, where somebody's arrested, they're taken to a courtroom, nobody knows what the charges are, nobody knows whether or what the evidence is. But our jury system also is a really good way to ensure that everything is public. And anything that's filed in court that is not under seal and protected is available to the public. You can go to the clerk's office and get all the material. As I said, you can go to the office, and if there's a court reporter there, you can get a transcript if you want to pay them. So generally good. Shadow docket? Nope. So that was the exception, because there's really just not much there to see.
Katie has her hand up.
Okay.
I just had another question about the shadow docket. They said that there's no oral arguments. So how do the justices talk to each other, or they just do their own research and come up with a decision, or how does that work?
Well, the issue will be presented in a limited briefing by the parties. The justices do have a conference in every case. So they do meet and they discuss it, and they all have, I think, 3 law clerks for research.
Okay.
And research. All right. Anything? I see no other hands. Let's see.
Okay.
So
Carry on. Okay. Sorry.
Okay, and so we've discussed this already. That there should be an effective enforcement mechanism for the federal judiciary code of ethics at all levels, and we have discussed that there is none at the Supreme Court level, but there is at the lower level. And this has some of the recusal language that I forget who talked about. Oh, no, it's not. It's the engaged in conduct prejudicial to the effective and expeditious administration. But if there's no questions about that, I don't have anything to add to what I already said.
Let's see. I think we've been through most of this.
I had a question. Can we go back to that previous slide?
Sure.
So what would that effective is it not relevant to this conversation because of the nature of the consensus that we're, the principal statements that we're looking at? But I'm just curious, what would that enforcement mechanism look like?
That would again be the chief judge of the circuit would look at any kind of complaint.
So it would rest with one person?
Yes.
And not sort of a committee or?
Well, they look at it just to dismiss the really frivolous, I didn't like the way the judge looked. So if it's a serious complaint, then the chief judge sends it on to a committee of the circuit conference, or I forget what it's called. Anyway, the circuit has a committee. They send it to that, and then they review it and look into it in much more depth and write a report, and they can impose discipline, which, as I said before, was the public or private reproval, taking cases away from the judge or referring it for impeachment. If they do that, then it goes to the Judicial Council. So that's what happens here.
Thank you.
Sure. And I think Kathy's next.
Sorry. But this doesn't, this question, statement number 7 says, for at all levels, and we don't have an effective enforcement mechanism about complaints at the highest level.
Right.
I think that I think is where the focus of our discussion should be, at how we could do that, if it's practical or if there's a way to do it, because there's no one to enforce it at the Supreme Court.
Exactly. I mean, that's the glaring omission in all of that is the Supreme Court.
So we'd have to come up with a way to enforce a code of ethics to make it binding and enforceable, and who would judge a justice.
And therein lies the rub as well, because and Jane had mentioned before that it's been mentioned that the Supreme Court justices could police themselves, and they don't want to do it, and there's nothing to say that they could do anything about it anyway. And also, they don't think it's appropriate to have a lower court judge look at what the Supreme Court is doing, right, and discipline. So that's another. But for the consensus issue, it's just, do you think there should be one?
Well, if it's possible, could Congress step in and provide an enforcement and just throwing that out there.
Yeah, it's for greater constitutional scholars than I, but and I'm not a constitutional scholar at all. But I don't see why something could not be crafted. But maybe not because of the wording of the Article 3, I don't know.
Okay.
Mel?
Thank you.
Other leagues, there's been this sort of listserv about this whole topic, and this has been the real stumbling block for other leagues that have already had their consensus meeting. And, what role could Congress have? And then would it require a constitutional amendment to bring in Congress more? So those are, two big hurdles for this.
Well,
Anyway.
yes, but I will say that the lower court judges are appointed under the same Article 3 as the Supreme Court. So that's why I'm thinking maybe there is a way to do it, but I don't know what it is. And I Mel, I'm sorry.
Yes, no, it's okay. It's an interesting discussion. I'm curious. Please tell me if this isn't germane to the topic of this conversation to this afternoon. But I'm curious about who can make a complaint about a judge. Can it be one of the jurors? Does it have to be an attorney? Can somebody who from the public who's viewing the trial make a complaint?
Yes to all of that. Anybody can make a complaint who has, well, I mean, if they didn't have any personal knowledge, then the complaint would be thrown out. But yes, anybody can make a complaint who has knowledge of something that is worth complaining about in all of the courts except for the Supreme Court.
And to whom does that
I'm sorry?
To whom is that complaint made initially?
It's initially goes to the chief judge of the circuit.
Oh, it does. Okay.
Yeah.
Okay.
And
I thought maybe it worked its way up to him or her.
No, it goes, well, I have a feeling they have staff that are looking at
Yeah, I would assume that too.
But it's, I think I mentioned that the websites for every court has a form that's it. Fill out this form, and this is your complaint, and it will be reviewed.
Okay, thank you.
You're welcome. Mary Ellen? Yes, no?
Mary Ellen, are you with us?
She's muted. She's muted.
Oh, yeah. Can you unmute yourself? You could go down to the lower one corner.
Okay, sorry. Can you hear me now?
Yes.
Okay. Here's my question, and I've had this question about everything that the administration has done since they've been inaugurated. They're blatantly, knowingly violating laws. But the judges can make decisions and say they're wrong and they're breaking the law, etc. But it's the administration that enforces the laws. So are they going to back these judges' decisions, or are they just going to keep doing what they want to do, which is what they've done so far? Anything? Am I missing something? Because I don't know who would enforce.
Well, that's the I was listening to some knowledgeable people who said it's not a constitutional crisis yet. They believe it's a constitutional crisis when the administration ignores a Supreme Court order. I don't know that I agree with that, but that is, I think there's certainly a lot of fear that we'll reach a constitutional crisis if the administration just flat out says, no, I'm a court order, breaking the law is one thing. After it's adjudicated and there's an order, if you ignore that's another. And the scholars are saying that it's the Supreme Court order that's going to be the test.
Huh. if they'll only enforce if the Supreme Court says to do it, we're in deep doo-doo. Because I think we know that the majority of the Supreme Court was politically picked, not for the first time, but certainly, you know, it's going to be interesting if they ever say no. I guess that's all I'd say.
Yeah, I'm still a little hopeful. So we'll see. We're all going to see. That's the other thing too. There are going to be some orders coming out. All right, and I have that's Susan, I think. Has her hand
Yes.
up.
On a very minor scale, I am adjunct faculty at multiple universities in the San Diego area. If we publish things and they're peer reviewed and somebody says your research is flawed or whatever, there can be retribution. Do you see any evidence of that where somebody files a complaint and another judge says, I don't, if I accept this complaint, you better not file something against me.
Oh, you're saying if a judge says that?
Well, yeah, like a retribution. If you say, if you file something against me and approve it, you better not ever question me.
Okay, well, yes, that would be subject to discipline and also require the judge to recuse themselves from any further dealings with that person. It would have to go to a different judge, ideally. Well, I'm saying
So
it comes down to a lot
there's
of,
a certain amount of Girl Scout and Boy Scout part of this.
we need to select people with ethics to hold these jobs, because so much goes.
That's the problem.
Yeah, it depends on their integrity.
Right.
Yeah, again, for years it's bothered me about the Supreme Court, and I sort of understand and I sort of do not understand the lack of transparency of their decisions, but that's just me.
Well, the merits-based decisions are explained, whether you like the explanation or not, or think it's adequate is another
Hi,
thing.
baby. Hi, Bobby. I'm a puppy.
Jen?
I love you. I love you. I
Hi,
love you.
I
love
was just wondering to speak on the ethics enforceable mechanism. Do we have a definition of recusal standards? Like, is that part of Article 3? Is that published and discussed? Is there a way to know more about what the recusal standards are, other than their basic definition?
I can give you the standards, the Federal Judicial Code of Conduct, the specifics for disqualifying themselves in a proceeding in which the judge's impartiality might reasonably be questioned includes, but is not limited to, a judge has personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceeding. The judge served as a lawyer in the matter in controversy, or a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter, or the judge or lawyer has been a material witness. The judge knows that the judge individually or as a fiduciary, or the judge's spouse or minor child residing in the judge's household has a financial interest in the subject matter in controversy, or in a party to the proceeding, or any other interest that could be affected substantially by the outcome of the proceeding. The judge or the judge's spouse, or a person related to either within the third degree of relationship, or the spouse of such a person is, a party to the proceeding, or an officer, director, or trustee of a party, acting as a lawyer in the proceeding, known by the judge to have an interest that could be substantially affected by the outcome of the proceeding, or to the judge's knowledge, likely to be a material witness in the proceeding. The judge has served, the last one is the judge has served in governmental employment and in that capacity participated as a judge, a counsel advisor, or material witness concerning the proceeding, or has expressed an opinion concerning the merits. Might be a little too much, but
No, thank you. Thank you. I thought we could use that recap. I read it in the information, but I think it's important to define
Yes,
here.
absolutely. Yeah.
And our next topic is recusals, so we may get into it in a little more.
Yeah.
At that point. Shall we move on?
If somebody has a burning question, keep your hand up and we'll answer it now.
Yeah, this was a little more about the internal disciplinary procedures.
Yeah.
I think we've pretty much covered this. Okay, so this is number 8.
All right, so enforcement. If this goes to the recusal, it should include, the enforcement mechanism should include a process to require a judge or justice to recuse him or herself. We've gone over this. When a reasonable this is the appearance of impropriety. When a reasonable litigant would believe that the judge or justice has a bias against the party or an issue raised. And the next section, 28 USC section 455, we went through all the bases for recusal. So we could just go to the next slide. And this is the Supreme Court's voluntary code of conduct. Should uphold integrity and independence, should avoid impropriety and appearance of impropriety, should perform the duties of the office fairly, impartially, diligently, may engage in extrajudicial activities that are consistent with the obligations of the judicial office, and should refrain from political activity. There is no explicit requirement to follow the law. All right, and that I think going on to the next slide, there's really nothing more to add there. So here, the recusal, that a judge or justice's decision and rationale to recuse or not recuse should be publicly disclosed in writing. In my opinion, and these are more my opinions based on being subject to recusal and also seeing what goes on, judges are assigned a lot of cases. They don't recuse ordinarily. That's an unusual circumstance where you're in a position, because once you're a judge, you really kind of cut yourself off from everything. So the reason a jurist would not recuse is always the same. It's because that person does not believe there's a basis for a conflict or an appearance of conflict or impropriety, and so they can be unbiased on the case. I mean, if they had to disclose that every time they got a case assigned to them, they could just get a stamp. I'm not biased. I'm not biased, and that would be the reason for that. As far as the rationale for recusal, if you had a judge saying why they recuse, that can affect the outcome of the case. Let's say the judge has $1 million investment in one of the companies that's subject to the lawsuit. Well, if they broadcast that the reason they're recusing themselves is because if the decision goes the wrong way, they're going to lose a lot of money, that's going to influence Perhaps the other judges are influence the outcome of the trial. There's also a judge could know one of the parties, let's say the defendant in a criminal case, is a thief because the person stole something from the judge. Well, if they say, I'm recusing myself because the defendant is a thief, well, that's going to affect the outcome of the trial. That's going to get information out in the public and to the other judges. That is not a basis for the decision in this particular case. So it has, and those are just things off the top of my head that I know in the state court, and I'm not sure for federal court, once you recuse yourself, you're not allowed to talk to the judge that's assigned the case. You're not allowed to read anything. You divorce yourself from that case completely. So this saying the reason you're recusing yourself would be antithetical to the whole reason of divorcing yourself from that case because you have a bias. That is my personal opinion. But does anybody have any questions on whether a judge should publicly disclose the reasons for recusing or not recusing? All right.
Looks like
Meryl.
Beryl, it's a hand.
My son owns a restaurant and somebody accused them of mishandling money. They've been in court for 3 or 4 years now, and judges just withdraw from the case. They don't say why. They just decide they're not going to judge it anymore, and then they have to start all over and drag out the whole thing. Is that okay to do?
Well, it's the judges. I mean, I'm assuming this is in state court, but
Yeah, I don't know. Yeah.
and it's the same in federal court, I believe. But a judge has a duty to sit. I mean, you can't be saying, "Nah, I don't want to do that case," because as you can imagine, there's certain cases nobody's going to want to do. So you really have a duty to sit. But if something comes up in the evidence, then and a judge realizes they have to recuse, then they have to. I think another thing that happens is the turnover of judges, and if a new judge comes on, sometimes cases are transferred to the new judge. So I don't know the circumstances of the changing judges. It's not ideal unless there's a reason to recuse.
Yeah.
Belinda?
Yes, I'm curious, who can request that a judge recuse?
I'm sorry, I didn't understand.
Who can request that a judge recuse himself from a case?
Oh, anybody can. You can request they do it, but that's a threshold decision a judge makes as soon as they get the case. Do they have a conflict? Is there a basis for a recusal? So if you have a case in front of a judge, just practically speaking, and they say, no, they're not going to recuse, and they disagree with your reason you're requesting them to do so, let's just say some lawyers might be reluctant, thinking that the judge isn't going to look at them favorably as they continue to argue their case in front of them. You'd hope that they'd be above that, but anybody can ask a judge to recuse. The judge can always say no.
I'm just, my concern is like, take Supreme Court Justice Thomas. There's definitely lots of conflicts of interest. And so the recusal process, it doesn't seem to be in effect for any of his relationships on cases that have been for him. So that's my question, is who can who can ask for recusal? And then is it mandatory then that a judge, respond to that?
Well,
or is it just something that goes to ether now and is completely ignored?
Well, it depends on the judge. If something's brought to a judge's attention and they're a person of integrity and ethics, and they go, oh my goodness, I didn't realize that. Yes, I do have a conflict. They will recuse. If it's somebody who's decided I'm the smartest person in the room and I can decide when I'm biased and when I'm not, and I can be unbiased in this, then they won't.
So basically what we're asking is that any decision-making process, that basically the judges start making a public statement about why they recused or didn't, correct?
That's the consensus. Yeah.
Okay.
Yeah.
Can I ask something about slide 7? Sorry to go back. Is there anything in here with whistleblower protections? I think one of the statements around when we were discussing slide 7 was that if I file a complaint, how do I end up, not being retaliated against? So I'm wondering if we're doing anything with a whistleblower protection around any of this. Just a thought. I don't need to put you on the spot.
I mean, ideally, they're. Let's just say all judges, I'm sure, have had complaints made against them because 50% of the people in their courtroom are very unhappy with them. So I don't think it's an unusual matter. So anyway, so if there is retribution, that would be inappropriate, and you can file a complaint about the retribution.
It might be something to put in the comment section on
Yes.
one. I think as most of you know, a lot of judges have been getting, federal district judges have been getting threats of violence. And, there's communication from all sides on, their happiness or unhappiness with these decisions. Anyway, Kathy's got her hands up.
Yes.
You are
you're muted again.
You are muted.
There, I am. I'm unmuted. This one, number 8, when we were discussing, an enforcement mechanism should include a process to require a judge or justice to recuse him or herself, et cetera, et cetera. One of the arguments we read in this literature is that the Supreme Court some of the justices do, feel that if one of them would recuse themselves, then there could be a tie 4-4 on a decision, and that would mean it was really a decision for whatever the lower court had decided. So that was a reason for them not to recuse themselves or to provide any explanation about it. So if we decide when we get to consensus that we want a strong support of that, I don't know where that would go.
I have that discussion somewhere in here, farther on down, and I'm not sure which category. Okay, it's the voluntary code of conduct. I think it might even be the next slide, or maybe it was a previous one. But yeah, in most courts, even say and I'm sorry to go to the state court again, but also in the federal appellate court, let's put it this way: if an additional judge is needed for whatever reason to have the appropriate number to decide a case, a trial court judge can be elevated for that case and sit as an appellate judge. So the Supreme Court has their duty to sit because they say no one can take their place if they recuse themselves. And you're right, it's the 4-4 tie, which actually results in whatever appellate court ruling to stand. it's not the imprimatur of the Supreme Court. It's not like they write a big decision and say the law of the land, but it's the appellate court goes. I personally don't see any reason why an appellate judge cannot be elevated to the Supreme Court to make for a one decision. They've been confirmed by the Senate, just like the judges in the Supreme Court have been confirmed, and let them go up and have an uneven number so they can decide a case. So I think the Supreme Court justices think that they are very special and the smartest people in the room, but I think that an additional person could go up there and decide the case. So I'm not so persuaded by that argument.
Thank you.
And that is under personal commentary. So
Thank you.
okay.
All right. On to the next.
Okay, the financial disclosure, the judges and justices all complete financial disclosures. They're rigorous. It's again, you're not going to be surprised by this point, but we come to the enforcement and penalties. And again, there are enforcement mechanisms the same way the complaints go through the lower court process and the circuit chief judge of the circuit and that kind of thing, all the way up to impeachment. For the Supreme Court, again, impeachment would be the only punishment because there's no, right now, there's no penalty enforcement. So, but they do, if they disclose, again, one of the, what was reported about Justice Thomas was that his financial disclosure has been amended now many times because people have discovered things that he didn't know that he had to report. So this one is devil lies in the details.
I just want to jump in for a moment to say I did go to the Judicial Conference website and was able to access the financial disclosure report for a federal judge who's been in the news a lot lately in Rhode Island. And I was floored by how much information there was. I mean, it was almost too much, for everybody to track, but an individual could track, what is in this disclosure report. It was completely available. I was kind of amazed. I mentioned that.
Yeah, they're public. All right.
Susan, you have something else?
Yes, I have just been really appalled at these book deals, especially, and speaking engagements I can understand, but Chief Justice Roberts couldn't even be sworn in public because one of the other justices had to have a book appearance in New York. It just, and then also, there was a lot of controversy about how she went to one of the school districts and told them they needed to have her book in their curriculum.
Who did that?
I'm sorry?
Who did that? I was just curious. What justice?
Tony Barrett.
Sonia Sotomayor, and quite frankly, I feel that she should never have been appointed to the court.
Right. Anybody else? All right.
Should we carry on?
Sure.
I think we have been through this.
Yes, we have.
Okay.
All right. Stare decisis. When a case is decided by a higher court and an appellate court, the courts in that circuit must follow that decided law unless the Supreme Court comes out with something else. If there is different law in another jurisdiction, the court cannot go to another jurisdiction and say, I like their law better, I'm going to follow that and not the one in my own circuit. They have to follow the one in the own circuit. The Supreme Court sets binding precedent on all federal courts and federal issues. Once the Supreme Court rules, that is the law, the way the law is interpreted. For years, well, it used to be very rare that a court would overturn, the Supreme Court would overturn precedent. We're a nation of laws. Everybody relies on the laws. They rely on them for business planning. They rely on them knowing what they can do in their personal lives. It affects everybody, and the stability of that law is very important. In the past, the Supreme Court required special justification to overturn a prior decision, not just a disagreement with a ruling. So, for example, Brown versus Board of Education is always marched out as, look, the court overturned Brown versus Board of Education. But the special circumstances there where there was more research showing the harm that there could not be separate but equal. And I think there was some more to it than that, but basically it was something new, and researchers said, no, this is a wrong decision. This is bad. And so they overturned it. And there have been a couple of others, but now it seems that the court is not reluctant at all to decide they never liked that case. And so now that they're in a position to do something about it, they're going to overturn it. And I don't think I'm speaking too blithely about this. I think that's exactly what they're doing. And that really, if the law is unsettled, our country is unsettled. We can't be looking at changing the decisions, the law, every time somebody new is added to the Supreme Court. So that's what stare decisis is. It's a settled decision that is the law of the land and is expected to be a decision made according to the Constitution and based on the facts. So I think your next slide, Jane, has to do with the Dobbs decision, and that was the abortion decision by the Supreme Court, where they did not require changed circumstances or advances in science as rationale for changing the law. The prior decision was not unworkable. The prior decision was not distinguishable. The quality of reasoning, they would say, was wrong. And it was consistent with subsequent related decisions. So it looks to me, and again, I'm going to make this personal, and I would say that they just didn't like that case. I mean, Justice Thomas didn't think there was a constitutional protection and thought the decision was wrong, and others did too, but Thomas had been saying that for a long time. And they just got enough on the court to go along with them, and they were picked because of that. So stare decisis is, to my mind, a very important concept. And I think the justices, when they went for the confirmation hearings, all pretty much said, oh, yes, settled law. Oh, yeah, we're not going to mess with settled law. But here we are. So that's stare decisis. Does anybody have any questions on that? Kathy, you're muted.
Here we go. I just want to say that I think that statement is kind of weak. My own personal opinion is that this shouldn't be happening with the Supreme Court. Some of their decisions that are changing, you know, past Supreme Court decisions. So I think maybe when we get to consensus, it's a possibility that we add strong comments. If we decide that we support that, yes, but maybe I would want to definitely put in a comment that something stronger needs to be stated. Some way to keep them from, you know, going back and for frivolous reasons or reasons that don't really hold up under scrutiny for overturning precedent.
Okay, shall we go onward?
Yes, let's go onward.
This is our last question.
This is it. Public perception of the Supreme Court's legitimacy contributes to a strong democracy. And there have been many discussions about what should be done. Should we pack the court? Should we, with increasing number of justices, which right now, depending on your leaning, would be a very good thing because Donald Trump would appoint more judges, or a very bad thing if you don't agree with his agenda. Are there also a discussion of term limits, and the town hall had, I thought, a very interesting discussion of term limits. Since these are lifetime appointments, you can't actually kick a judge off the bench unless you impeach them. So, but apparently you can put them in lower courts and they still have their lifetime tenures. So that's a possibility. It's sad that the Supreme Court, well, all courts, I've never seen anything like it in the last few years, is talked about in political term, all judges. It's no longer district court judge. It's a district court judge appointed by Obama, or a district court judge appointed by Trump, or whoever the president was appointing them. And it used to be that it was assumed that once you were a judge, you were going to shed all of that. And it really can be done. And then you are neutral and you decide the case according to the facts before you and the law, and for the Supreme Court, the Constitution. So a first step for me might be talking about all of the judges in political terms, and actually judging their decisions in political terms as well. I think any change to the Supreme Court term limit, term limits, or sending to lower courts, or packing the court, I think it has to be done with caution. There's always unintended consequences, and you know, who knows what happens. Rosette.
Yeah, so a couple of comments. I think maybe we should not use the word packing the court, because packing has I think the question is, do we want to expand the number of justices on the court? So
I agree.
Just a comment.
Yes.
It's maybe changing the language, but two other comments. I actually think the previous slide about stare decisis and this one about public perception are really, this one to me seems rather nebulous, and the one before also seems like a stretch. Like, I don't know why the league wants to be in the business of making judgments about decisions that the judges make. Like, sort of saying you cannot overturn, a previous decision, because the Supreme Court has overturned decisions in the past that we have been very happy about, right? With regards to expanding voting rights, and so for the Voting Rights Act and all those sorts of things. So I find that really problematic. And then this one here, public perception of the Supreme Court's legitimacy. Why aren't we taking a principled stand on, for example, term limits? Like, that seems to me like a more of a principled stand than just public perception. Public perception has to do with the way the media reports on the justices, the kind of information people are getting, mis and disinformation. And I watched that town hall, and I was really persuaded by the three panelists who talked about why an 18-year term limit, by the way, supported by the Cato Institute guy, and probably the two other young women who are progressive, liberals, why that made sense. So I'm not in favor of these last two statements at all, and I think they deserve a lot more conversation, because I don't think they're getting at. I think number 11 is wrongheaded, and 12 is not getting at, the sort of the root cause, the root problem, if you will. So just a comment there.
Okay, yeah, and that's fine. I will say stare decisis is not, it's a concept that's been with the court forever.
No, I get that. I'm very familiar with it. I know exactly what
Okay,
it is and what it's referring to. Yeah.
I have nothing to add then. Katie.
Well, I kind of see what Rosetta is saying about that the public perception is kind of a nebulous thing. I really do think term limits is an important point, because especially when you talk about the league and everybody else evolving with the times, people live longer. It didn't, someone who had a lifetime appointment wasn't going to be on for this many years. And so, and I like the idea of stare decisis, because I think the idea of that is that you do want stability in law, unless you can prove that the situation has changed, like women are considered human, well, then women should have the right to vote. Before they weren't, so the same thing with so that's my 2 cents on that. But I can see how this public perception of the Supreme Court's legitimacy, it's true, but it's just a really nebulous thing, and I don't think it's something that should be the focus. The focus should us saying, well, how does the legitimacy get returned? And maybe one of the ways it gets returned is that there's term limits. There's the stronger ethics thing. I mean, I find it really disturbing that the Supreme Court thought they could use the word should, and everybody else has to use the word shall. I mean, and to me, it's insulting to them, because they don't care if they're seen as legitimate. And that's a disturbing factor for me. As someone was saying about the whole Trump, what they're doing now is they don't seem to care that people are upset. And that is disturbing. That is disturbing. So that's just my 2 cents.
Okay, well, thank you for you and Rosette. I just wanted to say one thing, and that is that term limits per se, if you had a term limit, you have to amend the Constitution.
Yeah.
I just want to say a little something about the league process. There were a lot of people at the convention felt that 1 year was too short to do this, that this was a totally rushed job. So one thing for the leagues to consider in the comment section is, are there topics you might want to see the league look into further, such as term limits or, so a number of people have been complaining that it's too short a time, so. You can use the comments section for further steps.
And I'm not advocating, so I mean, I appreciate all your comments. Belinda? And you're muted if you're trying to talk.
I sure was. And it was a good thought. I understand the desire to want to, once something's been settled, to keep it forever. And I'm not totally in support of that. So thank you, Rosette, for bringing that to our attention. Also for number 12, perhaps this is a place where, again, we can insert something about ethics, because the lack of ethics and any type of ethics enforcement also dramatically affects legitimacy.
Yeah.
That's all.
All right. Thank you.
Katie, do you have a follow-up, or is your hand still up from earlier? Okay. I think, do we have any? Oh, I threw this slide in just because this was from John Roberts' 2024 end of the year report on the judiciary, and mentioning the violence, the intimidation, and then the threats to defy lawfully entered judgment. So I thought it summed up some of the ways the judiciary is vulnerable. But I think we're pretty much done. I do know that I'm going to stop sharing so we can look at each other instead. I know that Marianne had something she wanted to say to our group before we end tonight. Are you there, Marianne?
Yeah, yes, I am. Thank you. No, to the North County people, I'm so happy to see so many people here tonight. I wanted to say that on Wednesday, we're meeting at Agua Hedionda Lagoon from 4 to 5:30 down in the Mayor Matt Hall Hill area in the courtyard where we've met before, sort of down on the lower level, to talk about this. So we can continue this discussion. There'll be people who will show up who may not have attended this meeting. We can fill them in and talk and continue this discussion so that we're ready for consensus next week.
Great. And the San Diego League, we will have our meeting at 5:30 next week. Mary Hansen, who has been here throughout, is going to be our recorder, and I will moderate, and Stephanie will be on hand for advice or input. But Stephanie, thank you so much. Just your clear-headedness and, steering us to very good topics. I just want to thank you a lot. Is there anyone else who has something to add? Speak now, or so I think what we'll do is close down. It's just a lot to absorb, and I think an hour and a half is enough. So thank you so
Thanks
much.
very much, Jane, and thanks, Stephanie. We really appreciate all the work both of you put into this.
Yeah, well, we've been getting missives from the league, daily about this. So there's been a lot of input from around the country, which has been very helpful.
Yeah.
And one of the strengths of the league too. All right.
Oh, I just want to say one thing.
Yeah.
Just before, could you not close out? I was trying to copy the chat citations that Kim put in about Australia and Germany. I thought those were pretty interesting about their mechanisms for enforcing any actions against a sitting judge. So that'll just take me another few seconds. I did the one.
Okay, and I just saved the chat, so
Oh,
we'll have
how
it.
do I do that? Or
You
you?
know what? I don't, Kim, can she save the chat separate or?
I'm not sure if it allows everyone to do so, but if so, it would be the three dots at the top of your chat box.
Yeah.
If you click that and then go to save chat.
And Mona, I can find you too.
Okay, yeah.
You can, email me and I'll send it to you.
Okay, I think I got the two, Australia and Germany. But yeah, if you
Yeah.
and Canada, yeah, UK. Okay.
Great.
Thank you. Thanks. A lot of
Thank you, ladies.
Stephanie.
Bye-bye.
Good night.
night.
Thank you so much, Jane. Thank you so much, Stephanie.